This is Dr. David Shine, and welcome to Business Law 101. What is a landlord? A landlord has a right to collect the rent, has a right to tell the tenant they don't want to rent to him anymore at the termination of the lease, to get repairs to any damage done by the tenant. And this next one, pay interest on the security deposit. Remember, interest rates are virtually zero today. So most of the leases today do not provide for an award of interest. As we mentioned, warranty of habitability. Now, what we do know is that a property that's overrun with vermin, rats and mice and things, a property that does not have working heat in the wintertime, a property that the landlord prevents effective delivery of water and of course, making sewage properly available. So somebody moves into a house and the sewer system is completely blocked up and not usable. That's a very serious breach of the warranty of habitability. The Childs versus Peril case, one of the key elements there is that as a landlord who has rented older properties in the past, there is an EPA required notice of potential lead contamination. You want to do that early in the process if you've got people with little children moving in. The problem with little children is that they have a tendency to get in and do weird stuff and be close to the ground and occasionally chew on windowsills and do weird stuff that makes them more susceptible to lead poisoning. I would not recommend leasing an old house to people with little children, not because they can't legally rent it, but to indicate to them that there is the possibility of lead poisoning. It is much more significant for children than it is for adults because it impairs the development of lead poisoning impairs development. So it's serious for all people, but it's especially serious for young people. So in any event, the EPA does have a required form for a property built before 1978 when lead paint was banned for most applications.